I'm Gwenaël Limfeld. I'm a research professor in biogeochemistry at the French National Center for Scientific Research, here based in Strasbourg. And I'm also the director of the initiative in sustainability and the environment at the University of Strasbourg. I'm very pleased to welcome Noah Walker-Crawford. So Noah is a postdoctoral research fellow of the Economic and Social Research Council in Political Science at University College London. He is publicly engaged researcher on climate change and climate litigation. Noah holds a PhD in social anthropology from the University of Manchester. During his PhD, he spent a semester at the Howard Kennedy College as a visiting research fellow in the program on science, technology, and society. Alongside his academic work, he is engaged in climate justice advocacy. The work of Noah examines the knowledges and notions of responsibility at stake in discussions about climate change. His research looks at the use of science in climate litigation. So, Noah, please.
Thank you very much. It's great to see that so many people are still here so late in the afternoon. I hope you all managed to get a coffee in the break. And the same goes for the people following this on YouTube. Hope you're enjoying the discussion so far. And I'm going to try and entertain you all in the next half hour. So, as we've been hearing today, climate change and climate science can be a bit confusing for lawyers and judges. But as we've also heard, how climate is interpreted in a legal context is crucial for how climate litigation cases are resolved. And what I'm going to be talking about today is the challenges courts face when there are disputes about science and about what kind of science should count to decide on legal issues. Specifically, I'm going to be talking about how some defendants in different cases have reacted to climate litigation, specifically fossil fuel companies who've been sued over their contribution to climate change. And I'm going to use this as an example to reflect about the translation and legal interpretation of science in courts. And as far as climate litigation goes, there's been an interesting development in the past few years. Up until a little bit further back, a lot of fossil fuel companies were denying climate change. They were saying, it's climate science, it's ridiculous, humans aren't contributing to climate change, it's probably not even happening. But more recently, that's changed. And these days, at least in recent climate litigation cases, fossil fuel companies are saying, yes, of course, climate change exists, and we're very concerned about this, and we want to be part of the solution. But nevertheless, they refuse to accept any kind of legal responsibility to deal with the impacts of climate change and to reduce emissions. And one way they do this is through very creative scientific arguments, or more specifically, through creative interpretations of the science in a legal context. And so really what I want to say, or what I'll be talking about, is that we need to be careful when looking at how science is presented in a legal context, because potentially it can be presented in ways that ultimately run counter to what the science is trying to achieve. So today I'm going to give a brief overview of how science is used in a legal context, the differences between scientific and legal knowledge, which we've heard a lot about today already. Then I'm going to jump into some examples. I'll talk about 4 different cases and the strategies fossil fuel defendants have used to defend themselves against cases and to argue on the science. And then I'll end with a few broader reflections about what all of this means for climate litigation going forward. So, first of all, law and science are both regimes of knowledge production. So they're both, trying to figure out the truth, but they're doing that in different ways. So, science is all about understanding the world around us, about understanding how environments work, about how, humans and animals function. And this scientific knowledge production is a kind of a long, open-ended process. You know, scientists will do studies, they'll produce research, they'll publish articles, other scientists will pick up on that, and so science is kind of always in development, and there are always, you know, it's new insights coming out. While in a legal context, you know, to make decisions, courts have to figure out what's true. They have to determine, you know, they have to separate the truth from what's not true. And so courts in this sense are also trying to come up with knowledge, but in a much more closed sense. So while, like I said, science is open-ended, the judges want to know the facts. They want to know guilty or not guilty, responsible or not responsible. And so what that means in practice is that what counts as to be true or legitimate knowledge in science isn't necessarily a legitimate fact in law. And that's why there's this process of translation, like we've been hearing a lot about today. And then in doing this, legal practitioners are engaging in interpretation. They're fitting the science into the legal framework. But that can be quite a big challenge, especially when we come to an issue like climate change. And climate change is still a fairly new topic in a legal context, because as we know, legal systems are kind of evolve very slowly, and so far, well, we see an increasing number of climate change cases around the world in lots of different courts, including here in Strasbourg. There's still a lot of open questions about how existing legal standards of proof should be applied to climate change. So now I'm going to jump into some examples to talk about how these discussions play out in practice. And I'm going to be talking about 4 different cases, just to introduce them very briefly. The first one we've already heard about today in some other presentations. It's the case of Luciano Yuya against RWE. So this is a case of a Peruvian farmer who's affected by glacial retreat and flood risk in the Peruvian Andes, and he sued a German energy company trying to get them to help pay for measures to reduce flood risk in the Andes. So it's all about, it's basically, it's a nuisance case to establish causal responsibility in relation to climate change. And then another case is Milieu Defensie against Shell in the Netherlands. So this is a case brought by an environmental NGO trying to get Shell to reduce its greenhouse gas emissions going forward in the future. This case was actually successful at a lower court. So in 2021, the court ruled that Shell has to reduce its emissions drastically going forward, and the case is pending appeal. The first case I forgot to mention against RWE. This case is still pending in the German courts, like Rupert Stewart-Smith was talking about earlier. It was rejected by a lower court and then was later found to be admissible and is currently in the evidentiary stage. And then the final 2 cases I'll be talking about are from the United States. And so in the US, around 24 cities and states have sued major fossil fuel companies and CO2 emitters over their contribution to climate change. And so this has to do, for instance, with climate change impacts related to sea level rise that affect a lot of different areas. Also has some of these cases also have to do with the fact that the plaintiffs are alleging that these companies knew about the harms that climate change was causing and yet continued to engage in these forms of energy production. And the cases I'll be talking about are the ones by the city of Oakland against BP and others. So this mainly has to do with sea level rise affecting Oakland in California. That's been going on since 2017. And then the other case is Honolulu against Sunoco and other companies that's been going since 2020. And these cases have been bogged down in the courts for a few years over legal issues to do with jurisdiction of whether they should be heard in state or federal court. I've analyzed legal briefs and looked at court hearings in these different cases to see how scientific issues have been discussed. And I've also been involved in the Luciano Yuya against RWE case as an advisor to the plaintiff's legal team on scientific issues. And so in these cases, what I found is that there are a lot of overlapping arguments in terms of what the defendants are saying about the science, which in a way isn't surprising because in some of these cases, it's actually the same companies that are defendants or also the same law firms that are representing these companies. And what I found is that there are three broad strategies that these companies are using to argue on the science. The first is to say, it's not us who are causing the problem, but it's society as a whole. Then the second line of argumentation is to focus on scientific uncertainty and to basically say that, yeah, the science, is great, but it's not good enough to hold up to legal standards of proof. And then the third line of argumentation is to attack the credibility of individual scientists who are presenting evidence. So, and I'm going to go through these individually and give you some examples of how this looks in practice. So the first argument is to say that the science points to the responsibility not of individual companies, but of society as a whole. So what that means to say is that these companies, they aren't they haven't contributed to the problem. Rather, they contributed to the common good through their activities. And really, the consequence of that argumentation is to say that, this is a political issue. This shouldn't be resolved through the courts in terms of the responsibility of individual companies. And so this line of argumentation to blame society, I found that in all of these four cases I was looking at in different forms. So, for example, both Chevron in the Oakland case and Shell in the Dutch case cited the same passage from the IPCC's fifth assessment report, which says that greenhouse gas emissions are driven by population size, economic activity, lifestyle, energy use, land use patterns, technology, and climate policy. And in the Oakland case, Chevron's lawyers took this to mean that they interpret this to say that the IPCC is saying that emissions are not driven by oil extraction and production, but rather they're driven by economic activity. And in the Dutch case, Shell, citing the same passage, says that emissions are driven by energy demand, not energy supply. In the Honolulu case, Chevron says that it's actually misguided to blame a handful of energy companies, and they point out to the fact that the United States government even promoted the use of fossil fuels despite knowing about the dangers. So really what they're saying is, we were just, providing a public service through providing this energy to people that everyone needed. And they say that, through this, they were really providing a public good. So, for example, Shell says in the Dutch case that the company was serving fundamental social interests, satisfying basic human needs. They even go so far to say is that Shell, through production of greenhouse gases, was helping achieve the United States Sustainable Development Goals. And in a similar sense, RWE's lawyer said in a hearing in the German case that their emissions were produced for the common good to ensure an energy supply for the population. And so ultimately what they argue as a consequence is that political solutions are needed. So in the Honolulu case, Chevron says that, really climate change needs global political action. And Shell says in the Dutch case that it's the responsibility of governments to set the regulatory framework for addressing climate change and not the responsibility of individual companies. And what's important to say here is that the companies are making broad political arguments to say that climate change, is to blame on society as a whole, and that we need political solutions. And it's not to say that that's they shouldn't be saying that. That's a perfectly legitimate political position to have. But what's important to point out is that this is not something that the science says. That's we could say a kind of a gross misinterpretation of the IPCC to say that the IPCC says oil production doesn't lead to climate change. So that's why when assessing these kinds of arguments, it's important to consider, in what context they're being made and to see how, creative interpretations of the science can lead to potentially misleading lines of argumentation. So, the second point, after blaming society, another strategy that fossil fuel defendants have used is to focus on scientific uncertainty. The basic argument here is to say that, climate science is great for, helping us understand the problem, maybe even for, to come up with political solutions, but the science isn't good enough to hold up to legal standards of proof or to establish legal causality. And so here, it's important to point out that these companies, they aren't engaging in climate skepticism. They're not, questioning whether humans are causing global warming, but they're putting a lot of emphasis on the uncertainties in the science. And of course, this sometimes ends up going in the direction of what climate skeptics are saying, because climate skeptics also tend to highlight the uncertainties. And so, to give you a few examples of how this plays out in legal practice, in the Dutch case, Shell argued that the evidence only points to the company's indirect contribution to climate change. They said they've produced a negligible amount of emissions overall. Both RWE and Shell point to numerous natural and anthropogenic factors that are contributing or that are at play in global warming. So they say, yes, of course, fossil fuels are a part. They're not denying that, but they say there's also land use change, there's also volcanoes, and lots of other factors that have a role to play here. Meaning it's all maybe a little bit too complicated for us to really understand. Both Shell and RWE has also argued that to prove legal responsibility, really what you'd need to do is trace each individual CO2 particle. So when RWE, most of their emissions come from the coal-fired energy production over the past 100 years. So really what they're saying, what you need to do is go to the factory and see where how each individual CO2 particle is going up into the atmosphere and see what impact that's causing. But of course, that's impossible. That's from a scientific standpoint, we're never going to be able to do that. So really what they're doing when they're saying this is they're setting the standard of proof impossibly high. And finally, these defendants are highlighting the uncertainties in climate modeling. So, for example, in the Oakland case, Chevron's lawyer pointed to the fact that climate models are so complex that makes them prone to errors. The lawyer highlighted the fact that in longer-term climate modeling, there's a lot of uncertainty about exactly how high sea level rise will be, depending on, there are different scenarios, and it might be, 1 meter or 3 meters or much more than that. And they say that, well, if, we don't really know, then we can't establish any kind of legal proof in that regard. And then in the RWE case, there's actually been an attribution study looking specifically at the glacier at stake here. So this case has to do with a glacier that melted and led to a glacial lake filling up with water, and that causes a risk of flooding to the plaintiff and to around 50,000 people who live in the valley below. And we actually heard about this study earlier today in Rupert Stewart-Smith's presentation. He was the lead author on this study, and which, well, according to him, used the latest peer-reviewed methodologies in climate science. According to RWE's lawyers, this model is unreliable because there's insufficient temperature data available from the Andes. And in a sense, they're pointing to a broader issue, namely that in a lot of countries, especially in the global south, there isn't so much research and there isn't so much historical data available showing exactly how temperatures have developed in different places. But of course, that's the whole point of climate models, which have become very good at showing us, how temperatures have developed at different scales, even if, there wasn't a temperature, like a measurement station on top of every mountain in the Andes or wherever in the world. But here again, the defendants are setting the evidentiary standard extremely high by saying that, for this case to be successful, you would have had to have temperature measurements from this one glacier going back decades and decades, which of course don't exist. And this same study that looked at the attribution of flood of glacial retreat and flood risk to anthropogenic climate change also included some glacier modeling, so basically modeled how exactly this glacier has retreated over the past decades. And while it's not in question that this glacier has retreated, like if you go there, you can look at historical photographs and see like back in the day the glacier was down here and now the glacier is like way further up on the mountain because it's melted off. RWE's lawyers question the validity of this model because they say it's not precise enough in modeling exactly how the glacier retreated and like when it was where and how exactly that happened. And so they say the model isn't accurate enough. And so they conclude based on that even if such models may be a relevant instrument for science, they do not fulfill the legal standard for causation and evidence. And that really kind of summarizes this whole line of argumentation. So defendants are pointing to the uncertainties in climate science to say that, the science might be great, might be fun to read, but really it's, not very useful in a legal context. So, after blaming society, after highlighting uncertainties, the final strategy that these fossil fuel defendants have been using, according to my research, is that they attack the credibility of individual scientists. And so what they're saying here is that the authors of certain studies are biased, which means the evidence is illegitimate and it shouldn't count in court. So, for example, one important piece of evidence in both the cases against Shell and RWE is the carbon majors study. So this was a big piece of research done over many years which quantified historic emissions and linked them to individual companies. So it found that around 90 companies are responsible for 70% of historic industrial emissions, and it put specific numbers to that. So it said, I think highest up on the list is, ExxonMobil with something over 3% and Saudi Aramco with around 3% as well. And then a bit further down on the list, you have Shell and RWE. And with Shell, in the case in the Netherlands, Shell's lawyers argued that they found that part of the research underlying the study was commissioned by Greenpeace, and because Greenpeace is an activist organization, they said that these results are irrelevant. They should be discounted, even if they were published in peer-reviewed scientific journals. And then in the RWE case, there have been a lot of detailed discussions about scientific evidence because this case is one of the few that's gone into the evidentiary stage so far that's actually gone into detailed discussions on the science. And so when the court first entered the evidentiary stage, they wanted to appoint experts, independent experts to advise the court on the science because, of course, the judges themselves aren't scientific experts. And so they asked both parties to put forward examples of, who would be good, impartial experts to advise the court. And the plaintiff's lawyers put forward the name of Friederike Otto, who's a very well-known German climate scientist. She's often, speaks to the media. She's kind of one of these, public faces of climate science and very well respected. RWE's lawyers argued that she is completely biased, and as proof of that, they pulled up some old Twitter posts she had made. So, for example, once she shared on Twitter an article about a climate litigation lawsuit and said, "Oh, this is interesting," literally. And then RWE's lawyers put this forward as evidence, saying she supports climate litigation and she's biased against fossil fuel companies. And as additional proof of this, they took the fact that she had been a speaker on some panels organized by Client Earth, which is an environmental NGO engaged in climate litigation. So in this sense, being part of public discussions about climate change and climate law makes a scientist suspect. Then another example of this is, of course, I've already mentioned that an important piece of evidence in this case is an attribution study done by Rupert Stewart Smith, who spoke earlier, and a number of other authors. And Again, RWE's lawyers attacked these studies' authors, arguing that they were biased. So first of all, they claimed, without providing any proof, that the plaintiffs were involved in the production of this study, even though this was independent research. They also said that the authors have, quote, publicly positioned themselves as enemies of CO2 emitters. Maybe in the coffee break you can ask Rupert if he thinks he's an enemy of CO2 emitters. I'm not sure. As proof of this, again, they pulled up some of Rupert's Twitter posts where he was, posting about climate litigation. They also referred to the fact that when he was an undergrad, he was a member of a student group at the University of Oxford engaged on climate change. So again, it seems like any kind of interest or public engagement on climate change makes a scientist biased. And according to this line of argumentation, if the authors of relevant studies are potentially suspect, then the evidence is invalid in a legal context. So now, to slowly come to the end, I'm going to end with a few broader reflections based on the discussion of these examples. First of all, in climate litigation going forward, a key issue is the standard of proof, the standard of evidence, and how those standards are interpreted in relation to climate change. What we've seen in these examples from 4 different cases is that litigants or parties can creatively interpret legal standards to make any kind of evidence appear invalid by setting the legal standard impossibly high or interpreting it to be so high that any evidence that might be relevant doesn't end up counting. And so here, judges have a really crucial role in interpreting standards of evidence which were probably not designed with climate change in mind, which are much older than the broad public knowledge about climate change, and so judges need to figure out how to apply these standards of proof in times of climate change, and this is going to be key in affecting how a lot of these cases might turn out when they come to these fundamental scientific issues. Then a second point here is that scientific legal arguments are connected to broader ideas about how climate change should be addressed. So we've seen, how fossil fuel companies have interpreted some of the evidence, how they've said that, if scientists have some kind of interest in their subject matter, that means they're potentially biased. But, this line of argumentation can lead us to potentially absurd conclusions. For example, you might say in that sense that if a cancer researcher doesn't want people to die of cancer, that makes them biased in their cancer research. And that doesn't really make any sense. And of course, we have peer review in science, and one of the reasons for that is to eliminate bias. And that's why, especially studies published in high-profile scientific journals go through very rigorous processes of peer review before they end up being presented as legal evidence in court. And what's important to recognize here is that there are broader issues that are pushing researchers to study climate change, whether it's policymakers saying we need good knowledge on climate change, and that's one of the whole reasons that the IPCC exists in the first place. And this can also be public concern or even researchers' own worries about climate change. People probably aren't going to study climate change out of pure boredom. They're going to study it because this is an important issue to a lot of people in our societies. And so, what this shows us is that ultimately the production of knowledge on climate change is intertwined with people's concerns about the issue and ideas of what we should do about it. And a final point on all of this is that climate science and climate modeling obviously has limitations like any kinds of science, but climate modeling is still a crucial tool for addressing climate change, for understanding the problem and figuring out what we can do about it, whether that's in a legal or a political context. And so, of course, climate modeling is getting ever more precise and showing us, how climatic processes are working, what are the contributions, what are the impacts, what are the different scenarios over many years, depending on, what emissions we produce in the future. What's important to recognize here, and especially thinking about climate litigation, is that climate models aren't going to answer ethical questions about who's responsible for, who should take responsibility for climate change, or about which impacts are the most important to address. But climate models can help us answer those ethical questions, whether it's in a legal or a political context. And so, scientific models may have underlying uncertainties. They may tell, they're never going to give us absolute truth. They're never going to give us 100% certainty. But, scientific uncertainty isn't anything new, neither in law nor in policymaking. So, there are all kinds of other issues we've dealt with in the past, whether it's, the dangers of smoking or asbestos or, a whole lot different kinds of environmental pollution. And so, of course, it's a challenge in climate litigation to understand how this science fits into a legal context. But ultimately, it's going to be up to courts to decide what level of certainty is needed to answer legal questions about climate change. And just to end with a broader reflection on all of this is the question of, why are there so many climate change lawsuits in the first place? And one very important reason for that is that there's a sense of failure in climate politics, that we've had decades of discussions at a UN level, but political processes aren't producing sufficient solutions. That's neither to limit emissions to a more or less safe level or to a not so dangerous level, nor is it for addressing the devastating impacts of climate change around the world that we're already seeing, and of course we're going to see more in the future. So in that sense, there's a real governance gap on climate change, and we're seeing people's human rights affected. And so if political institutions aren't going to do their job of protecting people's rights, then ultimately it's no wonder that people are going to turn to the courts to have their rights protected. And so when these cases are brought, it's important that courts rely on the best evidence to resolve them. Thank you.